Hi, my name is Mike Landers with L7 Marketing Solutions, and I'm here today to interview Lisa Newman, attorney at law on the subjects of wills, who needs them and other documents you should have. Lisa, thank you for taking this time to meet with us.
I appreciate the opportunity and I'm glad to help.
Thanks, Lisa. Lisa, I'd like to start by asking, when does someone just need a simple will?
I think everybody needs a will. If you've got children or if you have any assets whatsoever, I think that it's important to have a will. A simple will usually is appropriate for people that have less than $1 million in assets.
Great. And speaking of assets, Lisa, are there any assets a person should list in their will?
I don't necessarily think it's important to list your assets in your will because over time your assets change. And if you list specific assets in your will, they can be sold or you can give them away during your lifetime. And then when somebody's reading your will, those assets won't be in the will. So I actually encourage people not to list specific assets in their will. I generally list categories like personal effects and your residence and things like that. But other than that, I don't like to list specific assets.
Lisa, what happens when someone dies in Texas without a will?
If you die in Texas without a will, the state of Texas dictates where your assets go. So if you're married and you die without a will, generally speaking, your assets will go to your surviving spouse, but not always. And if you are married and have children from a separate marriage, then half of your assets generally will go to your surviving spouse, and the other half will go to your children from your children. So if you don't want the state of Texas to determine where your assets are going, it's very important to have a will.
Thanks. And if someone does have a will, can they avoid probate?
Absolutely not. Your will is actually a document that goes through probate. So by having a will, you're not going to avoid probate. You're actually going to force yourself into probate. But if you don't have a will, you're going to force yourself into probate as well, only the probate's going to be much more complicated and it's going to take a lot longer.
Speaking of probate, how long does probate usually take and what does it cost here in Texas?
Probate in Texas is a very simple process, assuming that you have a will. If you have a will, there is generally a short 15-minute hearing at the probate court, and then after that, everything is done independently of the court. You have a few filing requirements, but other than that, you can be done with a probate within 90 days. And the cost can sometimes be as little as $1,000, including filing fees, but then when it's a very complicated estate, it can be over $10,000.
Wow. When someone buys a do-it-yourself will, are there any problems with this if they're just completing the fill-in-the-blanks and trying to do it by all as a holographic will?
There are lots of problems with the do-it-yourself wills. Most importantly, for a will to be valid in Texas and be admitted without having to bring witnesses into court, they need to have what's called a self-proving affidavit. And generally, when somebody does a do-it-yourself will, either the self-proving affidavit doesn't have the magic words that the state of Texas requires, or it's done incorrectly. In addition, in Texas, to have the streamlined probate proceeding, you need to have what's called an independent administration. And most do-it-yourself wills don't talk to you about the magic words that your will needs to have in order to have an independent administration. Just because your will is missing those things doesn't mean that it can't be admitted to probate. It's just more difficult to get the will admitted into probate, and it can be more costly.
Wow, that's interesting information. Lisa, if I have a will, is it okay for me to make changes, or do I really need an attorney to make those changes for me?
When you have a will, it's easy to make changes. Generally, they're made in what's called a codicil, and generally, an attorney should draft the codicil for you. You never want to write on the original will or strike through anything because that can invalidate the will and not make the changes valid. So generally, you would want to go talk to your attorney about making any changes you wanted to make.
You know, we've talked quite a bit about wills, but I have to ask you this last question. What other documents do you need besides a will?
No good estate plan is complete without what we call the ancillary documents. Any good estate plan would include a general durable power of attorney, which appoints somebody to make financial decisions for you if you become incapacitated, a medical power of attorney, which appoints somebody to make medical decisions for you if you're unable to make your own medical decisions, a directive to physicians, which talks about life-sustaining treatment and whether you want it continued or not continued, a HIPAA authorization, which allows your doctor to release medical information to certain people, and a declaration of guardian, which will appoint somebody to be your guardian. And of course, if you have minor children, you would also want a declaration of guardian for your children in the event you become incapacitated or you die.
Well, that sounds like quite a bit. I hate to think of anybody trying to do that all on their own. You know, you've provided us with a lot of great information. Do you have any closing thoughts or advice you'd like to give families about estate planning?
I think doing estate planning is one of the most important things that you can do for your family. One of the reasons that I decided to go into estate planning is because I really feel like I'm helping people accomplish goals that are concrete and can really help somebody when somebody dies and everybody's sad. And I feel like when you have an estate plan, you've put something in place for your family. So I think it's very important that you plan where you want your assets to go, who you want to take care of your assets, and who you want to take care of your children. Estate planning is very important. It should be done before you need it. If you're doing planning near the end of your life, it gets very hectic and mistakes can be made. So I always think people should do estate planning before they actually need it.
Lisa, I want to thank you for taking the time out of your schedule. And if somebody has a question, how can they best contact you?
The best way to reach me is to call our office, and that number is 972-248-7448. Or they can email me at lisa@wolfishlaw.com.
Thanks, Lisa, and we look forward to doing future interviews with you and appreciate your help.
Thank you very much.